temporary order to require both parties to be obligated to the remaining portion of that lease.
This case kicks off with a money question hiding inside a parenting fight. Can a judge force two exes to keep paying on a Georgia lease after both walked away? Watch the attorneys sprint to frame the narrative. Mom moved from Georgia back to Kansas. Dad says he moved to Arkansas to be near the kids, not for a promotion. Meanwhile, a temporary order already assigns each side their current residence, but that old one-year lease is the grenade rolling around the courtroom. Stick with me. We've got weekend schedules that hinge on calendar math, a fresh child support number that might trigger overpayment, and a judge who's about to turn a simple lease into a percentage-based obligation. Who actually owes what and when?
Does the temporary order address this issue?
The temporary order has each party being responsible for their individual residence, which each party is currently responsible for their own individual residence. However, the parties entered into a one-year lease agreement when they were residing together in Georgia. Mother then moved to Kansas, leaving father in Georgia. Father moved to Arkansas to be closer to the minor children, rather than in Georgia and Kansas. They're in Arkansas and Kansas. The lease goes until February. And so he was asking that the court make each party responsible for one half of that lease until it is up in February.
All right. Backing up a moment, Ms. Locke, what are the agreements that were reached regarding modifications of the parenting plan?
Sure, Your Honor. The parties have agreed that mother will have the second weekend of every month. That father would have the fourth weekend of every month. There's a divided residency situation, so that means they'll meet to exchange the kids, and all the kids would be together during those weekends. They've agreed to divide equally the breaks, so that would be summer break, Christmas break, and then they've agreed to rotate Thanksgiving. And I think that covers the parenting time modifications. There's some additional details, like as far as exchange location and times.
Quick reset. The parties just sketched a divided residency setup that keeps siblings together on alternating weekends. Mother gets the second weekend, father the fourth. They're splitting school breaks evenly, rotating Thanksgiving, and ironing out exchange locations and times. Why does this matter? Because consistent, predictable time blocks stabilize kids' routines and reduce conflict over handoffs. For viewers, divided residency here doesn't mean kids live apart full-time. It means they're with one parent day to day, then all the kids reunite during designated weekends. Engagement Q. Do you prefer a clean second, fourth weekend system or a simpler every other weekend plan? And for parents watching, would Thursday evening starts help with Friday school traffic or complicate homework?
That the parties have agreed upon.
Mr. Andrews, would you add anything or dispute anything that Ms. Locke has laid out regarding the parenting plan?
No, Your Honor. Other than a modification that we agreed to today, which was that the parenting time during the school year would be that Mr. Niblett would receive the second full weekend of each month with all three children. Tristan would receive the fourth weekend of each month with all four children, and that the parenting time would be extended to Monday at 4:30 p.m. if there is no school in session on that Monday. All of the other agreements regarding parenting time, holidays, they've all been reduced to writing through exchange of emails. So I don't have any doubt that there's not going to be any confusion as to what we had agreed upon, since we have that in writing.
Is the term weekend defined?
Yes.
What is your definition?
Your Honor, the parenting time starts Thursday at 7 p.m. and ends on Sunday at 4:30, which is part of the exchange times.
Quick reset. The parties just sketched a divided residency setup that keeps siblings together on alternating weekends. Mother gets the second weekend, father the fourth. They're splitting school breaks evenly, rotating Thanksgiving, and ironing out exchange locations and times. Why does this matter? Because consistent, predictable time blocks stabilize kids' routines and reduce conflict over handoffs. For viewers, divided residency here doesn't mean kids live apart full-time. It means they're with one parent day to day, then all the kids reunite during designated weekends. Engagement Q. Do you prefer a clean second, fourth weekend system or a simpler every other weekend plan? And for parents watching, would Thursday evening starts help with Friday school traffic or complicate homework?
All right.
So that would be the
Court's
definition.
real question is, Ms. Locke, is what is the second weekend of the month? For example, if
Your Honor, I don't know
month ends on Saturday the
if
31st,
it's my
or
end.
Sunday the 1st, is that the first weekend, or is it the first time Saturday and Sunday both fall in the same month, or what is the definition of second and fourth weekend?
And Your Honor, that is not something that Mr. Andrews and I had discussed, but I think we'll be able to reach an agreement about how that is to be defined.
Mr. Andrews?
It looks like he might be frozen.
I apologize, Your Honor. For some reason, the internet in my conference room went out. So I'm having to connect through my iPad.
All right, the court was discussing what the definition of weekend is. Unless the parties reach a different agreement, second weekend will be defined as the second time within a calendar month that both Saturday and Sunday fall within that calendar month. The
Okay.
fourth weekend will be defined as the fourth time during a calendar month. That Saturday and Sunday.
The judge just solved it. Second weekend, the second time in a calendar month that both Saturday and Sunday fall inside that month. Fourth weekend, the fourth such occurrence. That instantly kills calendar ambiguity and reduces gotcha scheduling. Also notice the court's tone, firm, practical, and forward-looking. When a court bakes in a clear counting method, it saves everyone from relitigating every month-end crossover. This is retention gold for you all. Precision language prevents chaos. Engagement. If your month starts on a Sunday, do you think it's fair that the partial weekend before it doesn't count? Or should parenting time follow school week cycles instead of calendar math?
Fall within that particular month. All right. And then the new child support number would be what, Ms. Locke?
It is, I just clicked away from that. I apologize. Give me 1 second.
Your Honor, it's $1,268 per month.
Yes.
Effective when?
Your Honor, we
did not
would
discuss that.
ask for it to be retroactive to the date of the filing of our motion to modify the first of the month, which would be September 1st.
Any objection, Mr. Andrews?
Your Honor, the concern is that may result in an overpayment, and this is a temporary child support amount. What I would ask instead is that the effective date be October 1. However, the court to reserve jurisdiction over any overpayment or over the issue of whether it should be retroactive back to the day of the filing of the motion and disposition of that overpayment.
All right, so your client's already received the full amount of child support that was originally ordered for the month of September?
I believe so, because I believe that an income withholding order was issued by the DCF, if I'm not confusing my cases.
All right, Ms. Locke?
Your Honor, I believe an income withholding order has been issued, and I know that my client privately remitted catch-up payments based on the original child support order from July. So he paid the months that were not caught by the income withholding order already.
Right, and I was thinking that he was effectively current on his child support obligation. So I would just ask if we reserve the issue of child support payable up to October 1 until a later date final order to be resolved either as an overpayment or not.
The
Since
new child support order is effective October 1st.
Now to money. 1, 2, and 68 month in temporary child support. The flashpoint isn't the number, it's when it starts. Mother's side floats September 1st. Father's counsel pushes October 1st, warning a retroactive start could create overpayment because an income withholding order already sent September money. The judge probes whether support was current via garnishment and catch-up payments. Why is timing critical? Because temporary orders are stopgaps. You don't want duplicate funds flowing based on overlapping mechanisms. Pro, move by the court. Reserve jurisdiction. Decide now what applies going forward. October 3rd. But keep the power to iron out any backdated imbalance later. Question for viewers. Should temporary support ever be retroactive when payroll deductions already hit?
All right. You've addressed some of the issues. Mr. Andrews, I'm curious about what your client's position is regarding this Georgia lease.
Your Honor, we essentially take two positions regarding that. Number one is we dispute that the reason Mr. Niblett moved to Arkansas was because of Ms. Niblett's move to Kansas. Instead, we believe that Mr. Niblett sought and obtained a better position within his company that required a move out of state, and that move was to Arkansas. He took advantage of that improvement in his position, and so he should be responsible for the lease payments that resulted from that decision. It's true Ms. Niblett did sign the lease to Georgia. This was a situation where Mr. Niblett's the one who chose to take the job and move to Georgia. Ms. Niblett did move down later. I think it was approximately 1 to 2 months after he had moved to Georgia that she did, but it was only for a brief amount of time before she then moved back to Kansas. The second issue is that there's a sizable disparity in income in this case. Mr. Niblett's gross income is $8,750 per month. His net income Ms. Niblett's gross income is $3,001 per month, pursuant to the child support worksheet. So he makes $5,749 more per month gross income than she does, and this is a case where we did not seek spousal support, despite the fact that this is a relatively long-term marriage and there's a significant disparity in income. We do not believe that the expenses on the domestic relations affidavit are entirely accurate regarding his ability to pay the Georgia rent. We would note that one of the expenses is $250 per month for school expenses, which would be $3,000 per year for one child. That seems excessive. Another is property tax is $247 per month. That's $2,964 per year for what would only be personal property taxes, since there's no real estate, I don't believe, in this case. Again, that seems excessive. Further, the credit card payments that are noted, that the total of the credit card payments was $1,278.94, but Ms. Niblett has indicated that Mr. Niblett would routinely put most of his expenses on his credit cards and then pay those expenses off at the end of the month, meaning that we believe that a number of the expenses included on the domestic relations affidavit are actually paid by the credit cards and then reimbursed through the credit card payments, which effectively is doubling up on the expenses on the domestic relations affidavit. So, for example, he spends $800 per month in food, but if that's being put on a credit card and then he's making payments on his credit card, he's getting credit on the domestic relations affidavit for the $800 a month in food, plus the credit card payments that's paying the $800 a month in food. And so for those reasons, we believe he has the ability to pay this Georgia rent. and that based on the disparity in income, it would be fair, just, and equitable for him to pay the Georgia rent since he's not paying spousal support. And further, we believe that the fact that he has two rents was a decision he made in order to better his financial prospects and not because of.
Here's the core clash. Who carries the Georgia lease after both left? Father says he moved to Arkansas to be closer to the kids. Mother's side reframes it as a career move, so lease fallout is his cost of advancement. Then comes the income disparity. Father grossing $8,750 mo, mother at $3,001 mo, a roughly $5,749 gap. Mother isn't even seeking spousal support, yet argues father's budget double counts expenses, living costs charged to cards, then listed again as credit card payments. That matters. If some expenses are paid by credit card and then repaid monthly, you can't count both the purchase and the repayment as separate recurring hits. Engagement Q. If a move serves both career and family proximity, who should eat the leftover lease? Shared cost, higher earner, or the mover?
Ms. Niblett moving back to Kansas.
Mr. Andrews, wouldn't you concede that once Mr. Niblett takes $1,268 a month out of his net income, transfers it to the net income of your client, that income gap, as a practical matter, narrows considerably?
I wouldn't say it narrows considerably, Your Honor. It narrows, but I wouldn't characterize that as considerable, given the fact that it's a pretty sizable. I mean, he grosses approximately $70,000 more per year than Ms. Niblett. I don't think that $1,296 a month in child support, helping her pay for the expense of the children, noticeably narrows that gap. So I would say that this is a case, typically there would be at least contemplated a spousal support obligation, given the disparity in income and the length of time these parties have been married. But we are not seeking that because we know that Mr. Niblett has expenses such as this Georgia lease payment. So I guess what we would ask is that if Mr. Niblett is going to ask that Ms. Niblett pay half of his expenses, that he provide spousal support.
It's like you're attempting to make what I think is perhaps a final issue in this case, a temporary order issue. Why does this lease issue need to be decided now?
Your Honor, the lease ends technically in February, so the party's obligation is through February. So we're asking the court to deal with it now because it's possible that the case will not be resolved by the time the lease is no longer an issue.
Okay. Have the parties completely moved out of the property?
Yes, Your Honor. My client has relocated to Arkansas, and obviously Mr. Andrews' client moved to Kansas some time ago.
All right. So both parties are, I guess, in default on the lease at this point, or are the lease payments being made by someone?
The lease payments are being made.
By your client?
Yes, Your Honor.
And I guess that would be another issue is I don't know what Georgia landlord tenant law is, but at least under Kansas, if you terminate the lease early, there's a obligation of the landlord to relet that property as soon as possible and at which point the lease payments would terminate. It can't just be left empty and allowed to collect those leases. So if the parties terminated the lease early, they're obligated on that under those lease payments until the property is re-rented. But I would expect that the landlord's going to re-rent that property, thereby obviating the need to pay the rest of the lease.
But that doesn't relieve the pressure of paying two leases until the property is relet, if it is relet during the contract period.
Plus, this court isn't aware that Georgia law would be as enlightened as Kansas law might be in a corresponding situation. The court determines that both parties are equally obligated under this lease. However, that there is a disparity in income which this court should consider. The court will require that beginning with the lease payment that would be due for the month of October of 2025, the parties will be responsible for payment of any lease payment due to the landlord in Georgia in proportion to their respective incomes as reflected by the most current child support worksheet. What is that percentage under the current worksheet, Mr. Andrews?
28% for Ms. Niblet, 72% for Mr. Niblet.
That will be the
Watch the judge thread the needle. First, a quick mitigation principle. If a lease ends early, a landlord should re-let the unit promptly. You can't just leave it vacant and bill the ex-tenants forever. Even while noting that's Kansas law and Georgia may differ, the judge signals fairness. Don't pay more months than necessary if a re-rent happens. Then the ruling. Both parties remain obligated, but starting October 2025, lease payments are split by current income percentages. 28% mother, 72% father. Why it's smart? It honors joint liability from when they both signed, while accounting for real-world ability to pay today. Question: is percentage-based apportionment the fairest way to split old joint debts after separation?
portion ordered by the court. All right, Ms. Locke, you were the attorney for the movement for today's proceedings. I trust that you would be drafting a journal entry stemming from today's proceedings, which modifies the parenting plan, modifies the existing child support order with a revised child support worksheet attached, and then setting forth the proportionate share of the lease payment as ordered by the court today. Is that correct?
Yes, Your Honor.
All right. And you have in your possession the actual updated child support worksheet prepared by Mr. Andrews. Is that also correct?
I have one that has handwritten modifications to it, so I would just ask that the actual modifications be made, and then, yes, I will have it.
Bradley refused to let me make the modifications. I don't know why, but it would not work. It would not save. That's why it's handwritten in.
I'll see if I can recreate it, and then, yes, I will have it.
I spent, I would guess, a good 20 minutes trying to figure out how to get that to work on Bradley, and it just would not work. So I decided I would go old school.
And Ms. Locke, if you can't make it work, and you very well creatively may be able to, a handwritten one is fine as long as the parties agree on the handwritten modifications to anything that's printed on the worksheet.
Understood.
Small but telling scene. The court accepts an updated child support worksheet, even hand-marked because temporary orders need speed and clarity more than formatting perfection. The judge instructs counsel to draft a clean journal entry that 1. Locks the parenting plan definitions, 2. Attaches the revised child support worksheet, and 3. States the proportional lease split. This is how courts keep temporary frameworks functional while parties negotiate the final settlement. For you at home, hearings like this often look informal, Wi-Fi glitches, handwritten edits, but they build enforceable scaffolding. Engagement. Q. Would you prefer a rough but fast temporary order today, or wait weeks for perfect paperwork while bills and schedules pile up?
We are talking about a temporary order here, so some flexibility I think is called for under the circumstances. Counsel, are we going to eventually need a trial date in this case on issues arising or still existing in the case?
I don't know. I don't think that I can answer definitively one way or the other whether this is going to be a case that has to go to trial. I still believe that we could work out an agreement. We kind of focused on resolving this temporary order issue. I spoke with Ms. Locke before the hearing that my next step is to start gathering the rest of the documents I need in order to submit a property settlement agreement, property settlement proposal. I think that we've pretty much, with this agreement, resolved the residency and parenting time issues. I'm not expecting that is that this agreement is meant to just only be a temporary agreement that's going to be modified prior to the final orders. I don't want to speak for Ms. Locke on that, but at least I'm optimistic that that's not going to be a contested issue. And I still think that once I get some additional information to make the proposal, that there's a good chance of success at settling the case.
All right, Ms. Locke, do you see things differently at this current time?
Not at this current period of time, Your Honor.
Very well. Then I'll allow counsel some opportunity for further discovery and further negotiation with the optimism that a comprehensive agreement may eventually be reached in the case. Then you can inform the court that you'll need an appropriate hearing date. All right, the court will look forward to receiving Ms. Locke's modification order with child support worksheet attached in the court's queue in the near future. Mr. Andrews, is there anything else we need to address at this time?
Not to my knowledge, Your Honor.
Ms. Locke?
No, Your Honor.
Very well. Then at this time, the Niblett matter will be in recess.
Summary time. The court locked in a precise weekend definition to stabilize exchanges, adopted a temporary child support figure with an October 1st effective date, while reserving disputes over any September overlap, and transformed the Georgia lease from a finger-pointing contest into a percentage-based obligation, 72% father, 28% mother, starting October 2025, with a nudge toward landlord mitigation if re-rented. Council will draft the temporary order and keep negotiating, aiming to settle property issues without a trial. Big takeaway. In family court, clarity beats chaos, and proportional fairness often wins when past agreements collide with present incomes. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And the meeting can be ended for all.
Thank you, Your Honor.